Good day, participants. Today we would be covering chapter number 6 of City 2 module. Chapter 6 is on legal liabilities. We would try to understand what do we mean by liabilities, what are legal liabilities, what are the various components of these liabilities, and how do a person becomes liable to another person or a third party. And first of all, we would understand what is the meaning of legal liability. Basically, legal liability is defined as obligation and responsibilities towards other person, and also which can be enforced by law. For example, any citizen of a country has got liability towards others. That is liability, he is liable for the safety of others. If I am living in my house, I should ensure that I do not emanate any kind of poisonous fumes from my house. So I have a liability towards my neighbor. Similarly, if I am running a factory, the output of my factory or the remnants of my factory should not harm anybody's land. If suppose some polluted water is coming out from my factory and it's going into another person's land, so it should not make his soil infertile, or it should not damage his crops, or it should not damage his building. So I am liable. So that way, we are all liable towards others. Similarly, if I am a motorist, I am driving my car, so I am liable towards any people who are driving on the road or who are walking on the road. If I knock down another person, so I am liable towards that person. If that person injures himself or herself or dies as a result, so I would be liable to pay the damages. And in some cases, I am liable to pay only the compensation in monetary forms. In some cases, I am even liable to be imprisoned. So, which are the various liabilities in which only monetary compensation has to be given, and what are those cases in which I can also be imprisoned? So, we can divide liabilities into two forms. One is legal liabilities, you can say civil liability, and other is criminal liability. So, a legal wrong. So first of all, we should understand, once again we will just repeat it, a legal wrong is a violation of the person's legal rights or a failure to perform a legal duty to a certain person or to the society as a whole. So that is a legal wrong. So in legal wrong, we can have a crime. Crime is basically, it's a legal wrong against society as a whole. That is, and it is punishable by fines. It can be punishable by imprisonment, and it can also be punishable by death, like hanged to death, like in India. In some countries we don't have that kind of punishment, but according to the law of the land. So the crime is when it's a wrong against a person, against a society. Therefore, whereas civil wrong, for example, breach of contract. Suppose I have done a contract with another party, and I have breached the terms of the contract. So therefore, I am liable to pay any damages to another person. So, for example, one person has bought an insurance policy from the insurer. Now, insurer has not been able to pay the claim or has refused to pay the claim. So that is breach of the contract. They have come out with certain excuses. So this party, the affected person or the affected party, can sue the insurer in the court of law. That insurer is breaching the contract. So therefore, the court or the consumer court or the civil court can award some damages. They can ask the company to pay the claim as well as damages to this person, as well as the court expenses, etc. So that is civil wrong or civil liability. Now, there is another terminology which is used in these kind of liability cases. Now, there are so many other civil liability cases. For example, in Western countries, these are very popular. Even in India, they have become quite prevalent. For example, slander damages, defamation cases. For example, one person has unnecessarily, tried to defame a person by a newspaper, a news channel. They may have written some defamatory articles against any person or shown a person in bad light. So this person can sue the other person. Because if the other person has written these defamatory articles without any proof, without any substantial evidence, so therefore he can sue the other person in the court of law. So that also can come under civil liability. So there is another terminology which is used, which is known as tort. Tort is also a form of, this is also called civil wrong. So normally we use this word tort. So it's a legal term which means civil wrong or a breach of some duty, and it can lead to civil suit for which damages or compensation can be recoverable. So it's different from, you can say, crime. Now there are various categories of torts. Various categories of tort, we can say one is by negligence, the other person is negligent. Now for example, how do we define negligence? What is negligence? Basically, negligence is defined as the failure to exercise the standard of care required by law to protect others from an unreasonable risk or harm. For example, a person is reckless, person has neglected, for example, a person is running a restaurant and he has not taken care that his gas cylinders are leaking, and still he is working. So that means the gas cylinders are leaking, the gas, LPG gas is leaking, so it will result to fire and may result to deaths and burn injuries to several people. So he is responsible to the society. So because of his negligence, because according to law, this was his duty to take adequate care. Similarly, if a person is a cinema hall owner, this is his duty because a lot of people would be coming to watch a movie. So this is his duty to provide all those safety measures, be it for fire, be it for if the staircase is faulty, the steps are not uniform, a person can break his or her leg. Similarly, escalators, similarly lifts, all public utilities. So this is the duty of the owner to take care of those. So if not, then it will come under negligence. So negligence is one kind of tort. So the meaning of this term negligence is based on the standard of care required by a reasonably prudent person. Prudent means a reasonably intelligent person. I mean, as per common sense. Now, second kind of tort is one is negligence. Second kind is nuisance. Now, what is a nuisance? Nuisance again can be of two types. One is public nuisance, other is private nuisance. Public nuisance, basically we can say a person is guilty of public nuisance who does any act or is guilty of illegal omission which causes any common injury, danger or annoyance to the public or the people in general who live in the vicinity or who occupy property in the vicinity of this person, which may cause them injury, which may cause them obstruction, which may cause them danger, which may cause them annoyance. So that is public nuisance. On the other hand, private nuisance arises out of the use of one's own property in such a way so as to cause physical injury to the property of another or interfere in his health or comfort. So that is private. For example, as I said earlier, for example, emission of smoke, smell, fumes, gas, noise, even noise also from one property. So it causes nuisance to others. So it's a private nuisance. Third kind of tort example can be trespass. Trespass means a trespasser is a person who passes through others' property without taking the permission of the owner of that property. So he or she is called trespasser. Suppose there is a land and any intruder comes in the land is called trespasser. So in that case also that can also become the case of a tort. Similarly, there can be tort for false imprisonment. If a person is falsely implicated in a case and is being imprisoned, so that this person can also again sue the concerned authorities. Similarly, tort for defamation, as I talked earlier. So these are the various categories of tort. Now, another category of tort can be, some torts can be unintentional, but still the person is responsible. But some torts are intentional torts, that is intentional civil wrong, you can say. For example, intentional tort is an act which is reasonably foreseeable to cause harm to an individual. I can foresee that it can cause harm to the other person. Still, I'm not negligible. I know it. So knowingly, I'm making certain circumstances so as to cause harm to the other person. So that is a intentional tort. For example, I want to implicate the other person in a false case. For example, if I defame the other person, for example, I put the other person into some emotional stress or implicate the other person in a case of fraud. So that is an intentional. Now there is another very important term according to the legal liability, which is known as absolute liability, or you can say the law of absolute liability. This is also known as the law of strict liability. Before understanding this concept, I would again take the participants to the concept of negligence. Negligence, if suppose one party wants to sue, A wants to sue B for the negligent act of B, then A has to prove that B was negligent in his care of duty. So there are four elements of this negligence. Number one, there has to be an existence of a legal duty on the part of B. If suppose, for example, I am walking on the road, other person got hit by a bike, for example. Now I am in a hurry, I am going towards my home, so I didn't stop to see this person. So that is not part of my legal duty. That can be a part of my moral duty, that I should have stopped and taken care of that person who was hit by a running vehicle. But I didn't stop, but nobody can implicate me that you were negligent. I was not negligent. It could have been my moral duty, that can be debatable. But it was clearly not my legal duty because I am a third person. But yes, the person who knocked him down, or the person, although the person may not have knocked him down, but he just screeched his vehicle just near him. So this person, all of a sudden he got frightened and he fell into a ditch. For example, this situation can happen. So he can sue that you were not negligent. You should not have put on the brakes like that. You should have driven your vehicle carefully. Right? So you are understanding. So first of all, first element, if A wants to sue B on charges of negligence, there has to be an existence of a legal duty. Whenever you are moving on a road, even if you are walking, so you have to take care that the other person do not get hurt. If I am walking, it doesn't mean that I will just, even if I am walking, it doesn't mean that I will hit the other person to make way for me. So that is my legal duty, to take care of other person. Number one. Number two element is that there should be failure to perform the duty. Number one, there should be existence of duty. Number two, failure to perform that duty, this person will have to prove. Number three, there has to be a damage or injury to the claimant. If B did not inflict any injury or damage to A, then why A will sue B? There can be a legal duty. There can be absence of legal duty also, but if he is not harmed, he cannot sue him. So there has to be injury or damage due to that legal duty. And number fourth element requirement is that there has to be a proximate cause between the damage or injury and the event. Proximate cause. What is the meaning of proximate cause? Means for example, two person, they had an altercation. So they had heated discussions between them. Now, suppose A and B had heated discussion, for example. So A spoke in a very harsher tone to B. So as a result, B had a heart attack and he died. So can he sue A because he spoke so harsh words? So I want to sue you. So it has to be established in the court that because of his harsh words, his heart failure took place. Otherwise, there has to be a direct relationship. The cause of the event should directly relate to the effect. Cause and effect relationship, you can say. So that is the meaning of proximate relationship. Proximate cause should be established. So number one, to prove negligence, there should be existence of legal duty. Number two, there should be failure to perform that duty. Number three, there should be a damage or injury due to that negligence. And number four, there should be a proximate cause relationship between the negligent act and the infliction of damages. Right. Now here also there are several cases of negligence. There are various elements. Number one is contributory negligence. Second kind of negligence is comparative negligence. Contributory negligence, if both of them were responsible for a certain event. For example, let's take the same example. One motor vehicle is moving on the road and another motor vehicle is also moving in the front. The front motor vehicle all of a sudden applied brakes and it's on a highway. And so the rear vehicle, it collided at the back of this front vehicle. Now this rear vehicle will also held the front vehicle responsible that you should not have applied the brake all of a sudden on a highway when you are going with a speed of say 80 km per hour or 100 km per hour. So the front one will say, no, you are responsible, you should have driven it carefully, I could have applied the brakes. So I mean, in certain cases, there can be contributory negligence by both the parties. So there are various laws, according to the law of the land, they can share. Even in America, for example, there are so many laws. They will see whose contribution was greater, either A's or B's. If A's contribution towards that act, towards that negligence is 60%, and B's is 40%, then they will share the damages 60-40. Even if it is 50-50, then 50-50. Otherwise, if it is even 49, it can be 51. So like that in US, these kind of laws are there. In India, although we don't have very, right now I have not heard of such kind of 50-49, but definitely we try to assess. On the other hand, comparative negligence is a situation wherein even if the negligence of the other person is even if the negligence of the other person is not proved, the other person is liable to pay to the other party. So there are several rules in that. Whereas in the case of contributory, again I will come to contributory negligence. In the case of contributory negligence, if you cannot prove, I will come back to that example where a person applied the brakes all of a sudden. So the rear vehicle can say, no, you are also equally responsible for the negligence. So I will not pay you anything. So it may result that they may not pay each other anything. One person cannot hold others responsible because you are also negligent. So contributory negligence, both of them were equally responsible for the negligence part. Whereas in comparative, you have to compare who was more negligible, who was less, who had less negligence. Now we come to, after having understood this, now we come to law of absolute liability, of law of strict liability. Absolute, as the name indicates, or strict liability, here the liability is imposed by the court of law or by the law of the land, irrespective of negligence or fault. That means one party does not have to prove that the other person was negligent. Even if the other party was not negligent, the other party has to pay the damages. So that is the law of absolute liability. The plaintiff means the person who is a claimant. Whereas defendant in court language we saw say defendant is the person who is defending himself or herself against any claim, any damages. So plaintiff means the person who has sued the other person needs to only prove that the event happened, that the tort happened or the civil wrong happened, and the defendant, and due to the defendant, due to this party, he was present. It doesn't have to prove that the other party was negligent, only because it happened because of other party. That's all. So that is the law of absolute liability. Now, in which cases this law of absolute liability is applicable? For example, the owner of a circus. Let's take an example. Owner of a circus, he is having show with wild animals. He is having cages where there are lions and tigers, and he's having a show before the audience, and all of a sudden a lion comes out of the cage and pounds upon the audience, and as a result the audience, either one of the person gets killed or gets injured. So this person is responsible. We can't say that the animal became wild all of a sudden, although the animal was trained and there was no negligence on the part of the circus owner. May say, we were not negligent, we took all care, but he's a wild animal. We can't say, no, they are responsible. This is law of strict liability. These people come. Whosoever is dealing with dangerous animals or with dangerous substances. For example, a factory manufacturing explosives. Whatever accidents may take place, it may not be due to the negligence of the owners, but still they are liable for any damages, for any kind of harm to any other person, whether injury, whether by in monetary terms, whether due to death. Similarly, blasting operations, in mines and other places, in mountains, sometimes government take place the blasting operations, sometimes private parties they take blasting operations. If anybody injures, anybody is harmed, anybody is killed, the person is responsible. So that is law of strict liability. Similarly, crop spraying in other Western countries, there is crop spraying by aeroplanes, by airplanes. They spray on the crops, spray of fertilizers, medicines by helicopters. So due to that, that spray, it falls on some person, so some person's field is, or some person's building is spoiled, so they are responsible. So, there are certain occupations. Similarly, in Workers' Compensation Act, according to Workers' Compensation Act also in our country, if a worker gets injured in a factory while due to occupational hazard, due to occupational disease, then the employer is liable. The employee doesn't have to prove that it was because of the negligent conditions here, because the working conditions were bad. No. Since he was on duty and he or she was injured, for example, in a factory, so even in that case, one does not have to prove that the employee was negligent. Even if the employee was not negligent, the compensation has to be given. So these are few examples which come under law of strict liability or law of absolute liability. Now, there has been a concept called imputed negligence. Imputed negligence. Let's see what is this. Imputed negligence means that under certain conditions, the negligence of one person can be attributed to another person. For example, imputed. For example, employer-employee relationship is said to be an imputed relationship. For example, let me give you an example. For example, an employee is going for some official work in the official vehicle. For example, these days we have so many call centers and BPOs. The drivers of these call centers, if they injure anybody, then it's not the driver will be held responsible, but the company can also be held responsible because it was the company's vehicle. Many times if they are outsourced these vehicles, then the contractor is held liable. It's not only the driver which is held liable, the owner of the factory or the owner of the company also are held liable because of the law that sometimes it happens that this person, he was working for a particular employer. So the employer is responsible. So that is imputed wherein one liability is being allocated to another person through this person. So that is imputed negligence. So in many cases, here also, for example, a minor boy, he gets hold of a loaded gun and he shoots some people. So the parents will be held responsible because he's a minor boy and he's the agent of his parents. Now there are various terminologies also used in this legal liabilities. One is a Latin word which is called res ipsa loquitur. Res ipsa loquitur, it means the thing speaks for itself. The thing speaks for himself. This is the literary meaning. And under this doctrine, the very fact that the injury or damage occurs establishes a presumption of negligence on the part of the defendant. It is then up to the defendant to refute the presumption of negligence. That means the thing speaks for himself. For example, a person has gone to a dentist to extract his tooth, and instead of the right tooth, he extracts the whole jaw, or he extracts the wrong tooth. So he doesn't have to prove the negligence because the thing speaks for himself. Because I had this tooth was troubling me, and he has taken out all my tooth. Similarly, if a doctor leaves sometimes a piece of cloth inside the stomach while doing the surgery, or leaves a piece of scissors. Many times we read in the news. So the thing speaks for himself. They are well clear. So this is the meaning of this term. Res ipsa loquitur. Similarly, there are other terms also. You just see, these are very interesting terms. Another is voluntary non-fit injuria. Voluntary non-fit injuria. It means that to him who is willing, there can be no injury. To him who is willing, there can be no injury. For example, some blasting is going on, and the authorities have taken due precautions to inform all the people that nobody should come in under this vicinity. So they have also put some barricades. Some blasting is going on, but still if some person is going knowingly that there is a risk involved and if he gets injured. So these are some of the defenses which the defendant can take, that voluntary non-fit injury, the one who is willing to go to risk himself. So how he can hold the other person responsible. So I mean, this is one of the examples. Similarly, if there is a football match going on and all of a sudden, a person is caught in the frenzy in the crowd many times in Western countries, in football matches especially, because he had gone there on his own will, and if he while dancing and all on and while cheering he falls down, so that he cannot hold the other person responsible. So this is another concept. Similarly, there is another third concept which is known as vis major. This is another Latin word, Latin of, some are French words, some are Latin words. Vis major means it's act of God. Many times it happens, like natural calamities, sometimes floods take place, tsunamis take place, earthquake take place. So due to that, some property is damaged. So one cannot hold the other person liable. It is an act of God. Like last year, before last year, there were very heavy floods in Mumbai, and most of them had complaints and against the government, state government over there. So one of the persons from the state government said, it's an act of God. So why you are blaming the state government? Okay, we were not prepared for this thing, but we didn't know that nature will have so much of fury all of a sudden. So sometimes these kind of defenses are there. Now let's take a very quick look at problem is there. Even if a very poor person, even if a beggar is knocked down, the family of the beggar would also like to have a huge compensation, because they will say that he was a young age, he was in the prime of his youth, so had he been alive, he would have earned this much. So now compensation costs are rising to great proportions. So therefore people also want to insure themselves against these liabilities, various liabilities. There is, you can say, workmen's compensation insurance, which compensates the employers in case of certain liabilities. There are professional indemnities, which insures professionals like chartered accountants, doctors against any legal case against them, lawyers. And similarly, we have third-party liabilities in motor vehicles. That is compulsory in India. The only insurance which is compulsory in our country, in India, is third-party liability. In any case, if you want to drive your vehicle on the road, you have to insure yourself against any third-party compensation, which in any case you will not be able to pay. Unfortunately, something like this happens. So we have our justice system. We have, we have our federal system. We have a Supreme Court then at the center, and we have several states. And each state has got high courts, which is headed by the High Court Chief Justice. Similarly, we have Chief Justice of India at the Supreme Court. So there are different eligibility conditions for these judges. Then we have a general who is appointed by the president, and under Attorney General there are Solicitor General. One is Solicitor General, another is Additional Solicitor General. Similarly, at the state level, the governor appoints a Advocate General. So we have these high courts, and all districts have got district courts, which is headed by district and session judge. District and session judge again looks after the civil cases as well as the criminal people. In civil we have magistrates or munsifs, and in criminal courts we have chief judicial magistrates and other people. So now, in order to ensure that these kind of cases are disposed of quickly, we have what we call as lok adalats. So lok adalats sometimes, many times, are voluntary agencies which are monitored by state legal aid and advice boards. And every award of lok adalats is deemed to be a degree of the civil court or order of the tribunal, and it shall be final and binding on the parties to the dispute. So either through lok adalat, then we have consumer forums also in our country, then we have MACTs, motor accident claim tribunal, to dispose of third party motor claims, by which there is a hope that people have hope that their claims, such kind of liability and tort claims, would be disposed of quickly and in an efficient manner. Thank you for the patient hearing, participants. From the participants here present, any questions? Okay, thank you, participants.